Good morning, everyone. As usual, every our Saturday, we start with knowledge session and we are here again. And today we are having with a very vibrant topic and evergreen topic, I will say. This topic is always evergreen and we always keep on discussing and people keep on checking about the importance and the complexity because it's very subjective, independent director. And if you ask, even I myself is independent director in my companies. And as a director, otherwise also you are responsible. And when it is independent director, you are more responsible. And it's not easy task. You can't be at ease anytime. And especially listed company, anytime disclosure, no insider trading, paid and all that. So better, of course, never to invest in the company where you are director. That is the best thing to do so that you are not in a problem. Also tell everyone in your relative, friends, boss, I am a director, I am director, so that no one, please don't invest, and otherwise you are taking responsibility. And in addition to that, when you are the member of different committee, you have extra honors other than director. So that the moment you are labeled independent, it carries the lot of responsibility, and hence this topic is always discussed, churn, and it keep on churning that how it will be affecting independent director and how a director will be independent or will be termed as is acting independently. So today's we have our own Vallari, and welcome Vallari, and thanks for your time. Though you are at your home at today, but you have taken out time. Thanks for that. Our own Mr. Bala, welcome Mr. Bala, and Silas Bhai as usual, and all the participants, thanks a lot for your time. And I wish you all actively participate as we discuss this, our chat discussion. Each participant is expert in this. It's only for administrative purpose we create this panel, but I expect each and every participant to be expert. We learn every day. And with that, I will request Vallari to say a few words on the topic, and then I'll request Mr. Bala to say a few words, and then we can start the presentation. But before that, I'll just introduce Vallari, our panelist. Vallari Gupte is a commerce and law graduate from the University of Pune, fellow member of ICSI and ACSIS from ICSA UK. Currently, she is working as a general manager, company secretary and compliance officer at CS Limited. She is member of ESG Council and Sustainability Task Force at CEAT, responsible for the integrated reporting of RPG group of companies. With total post-qualification experience of over 18 years, she has worked in the corporate secretarial and legal functions of various multinational companies and listed entities like Bajaj Holding, WNS Global Services, Tech Mahindra, KPIT Technologies, and Thermex. She has been actively associated with ICSI previously as a member and chairperson of Samhita Subcommittee of Pune Chapter, and currently as a faculty member for MOCP sessions of Pune Chapter, as well as Corporate Leadership Development Program organized by CCGRT Mumbai. She is also speaker at various seminars, webinars organized by Pune Chapter and WRC Mumbai. Under the Empowered Women Drive of ICSI on the occasion of Women's Day in the year 2020, she was recognized as a successful company secretary under 40 and was also invited as a panelist on the occasion of Women's Day program organized by the Pune chapter. Such a wonderful achievement, Vallari, at really early age. It's commendable. And welcome to this Mehta Mehta knowledge session. I'll request you to put few words on the topic, and you want to say, and then I'll request Mr. Bala to give few words on the topic.
Congratulations, Vallari. I'm really delighted to hear this.
Yeah.
Very good. Great.
Thank you, ma'am. And thank you for giving me this opportunity. Good morning, everyone. And as ma'am said, yes, this is an evergreen topic. This has been evolving since a very long period when the concept itself was introduced in India through the listing agreement, through corporate governance. And till date, we see that there are so many changes, so many amendments that are coming up to the provisions. So while the concept itself has been quite old, we know that it is ever evolving, it is dynamic, and it is not just the statutory aspect, it is the nature of the person, the character of the person that is brought by him on the table when he's on the board. That is very much important. So what determines a person to be independent? As company secretaries, I think the first thing we look at are the definitions under Companies Act or the listing regulations. But the first and foremost line in the definition is person with integrity, person who is having that expertise. And that's very much important for an independent director to be associated with any company. Because of course there are statutory frameworks, statutory provisions for the person to contribute on the board and direct the board members for their decisions. That's how I think the role of independent director is important. One aspect I think we always think about is whether the independent director is truly independent or not, depending on how he's associated with the other board members or the promoters. So this I think over the session we will discuss in detail, but I think one practical aspect that comes up is that no promoter or no owner of the company who desires to grow the business and take it to a larger scale would want just an outsider or someone completely unaware of the business to help on the board. But the person who is also known about the businesses, the practices, processes, but who's watchful about the decisions being taken by the board is, I think, the right balance for someone to be an independent director. So we cannot look at both the extremes, someone who's completely close to the board and is just nodding his head for any decision, and someone who's completely an outsider who doesn't understand the promoters or the business. So that's, I think, one important aspect that I think over the session we will discuss also. Over to you, Bala.
Good morning to all of you. I think today's session will definitely give me a good opportunity to enhance my further knowledge on this independent director. Because certain things, when we talk about the independent director, it is very good. He is going to balance the conflict of interest. He is going to take an unbiased decision. He is actually bring expertise and he will make the decision-making process better. Everything is actually fine. But ultimately, when he is appointed as an independent director, he fulfills everything. He is truly an independent director, he is appointed. But post-appointment of the independent director, whether he still continue to remain as an independent, whether necessary safeguards are actually provided in the law, whether he is actually given the necessary support from the management, that only will depends upon his independence. Because what happens is independent director, as you know, is not involved in day-to-day affairs. He doesn't come to the office every day. He comes only at the meeting times and maybe 4 times mandatory, as and when necessary, maybe 6, 7, 8 times. That is the time he meets actually. And he gets the informations. Whatever the information is sent to him, he goes through it and all, that's all available. Whether the information given is disclosed everything, off disclosed, full disclosed, strictly disclosed and other thing and all, it is again questionable. Although we have been talking about this topic for so many years, we know what happened in the history. The first ever thing which is known as the India's Enron Satyam case. Satyam was one of the very successful company, almost about 25 years. I think probably they started somewhere in the 80s. It collapsed somewhere in the year 2008 or 2009. How many awards they have won? What are the recognition they have got? Who are the people who are there actually? D. Merrill was the financial advisor to the company. HSBC Bank and SDFC Bank, Citibank were the bankers. One of the big 4, PwC was their auditors. With all those things, ultimately, financial fraud. Big scam which has taken place. And of course, independency, again, the popular case which we all know in the recent times is actually Tata, Cyrus Mastri and Nestle Wadia. They have removed 5 years, the case went on, it went to NCLT. Finally, NCALT has decided. That also we all are aware of it. But again, is the independent director, how far they are held responsible, how far they are there. One thing is there, because the SEBI also very clearly says, whatever happen in the board process, that means if they are involved in the board meeting, the board process is actually taking place, information given provided to them. Based on that, if they are party to it, if they are actually not acted upon it, yes, they are actually responsible. That is what talks about it. So that means the restrictions with reference to only the board process are involved. In fact, if you all remember, I think Shailesh Boy and Dipti also would be remembering it. It has happened about 10, 11 years back, I think. If I'm not mistaken, it was one of the listed company, I think some Pyramid Sai Mara Theatre Limited or something like that, where they have manipulated the accounts, falsified the accounts, inflated the profit, etc., and other things. SEBI has actually taken up the complaint, and three of the independent directors of that company was actually debarred being appointed as the independent director, specifically in the audit committee in any other companies for a period of 2 years. But the question is, they said the independent director should have known and other things and all this. But in this particular case, if we actually go into the details, if the thing is actually, what we call window dressing, we call it. If it is window dressed, what is the way for the independent director to find out? That is what it appears to be. And again, listed company, all right, it is various checks and balances, there is a listing agreement, there is a SEBI comes into the picture, Companies Act comes into the picture, various regulations there, they are governed actually. But unlisted public companies, we are governed only with the company. So in which case, in the unlisted public company, most of the companies, I think I would actually ask the participants here to share with their practical experience, whether really they are remaining independent, they are only marking their attendance as an independent director because law requires. That is the next question which comes into my mind. I'm not saying all the independent directors like that. There are people who are there, but the only thing is we are talking the larger good we are talking about. With all the things, the question is, to my mind, today, independent director is also a director like any other director only. That is there. But the responsibility is actually thrown upon to the independent director much more than any other director. They are held responsible, regulatory things are all coming, etc. and other things. So how far they should, how far the facilitating them to be an independent, much it depends upon with the company management, company people. That's what I think. Moreover, there should be more safeguard aspect rather than, responsibility and punishing them and giving them, providing them. According to the responsibility, there should be also more safeguard should be there. I do not know how it is. I think probably in this August gathering, we will learn something more from the people. Of course, Vallari is there in the corporate sector with a large experience. She will actually share her experience. We also have the very learned people. As we go along, we'll learn. I think we'll get some insight information from the people from the practical point of view. That's it. Anyway, it's a very, very interesting topic. It is going to be not a one-day topic. It is going to be ever discussed again and again. It is going to come. There are various changes. Already, SEBI has selected a lot of changes in independent director, which you are all aware. Their appointment, reappointment, special resolution within 3 months, shareholders approval, and again, RPT transactions to be approved only by the independent directors. So many things have actually come.
Which we will cover in this PPT so far.
Yeah. So that is it. So let us go ahead.
Yeah, thanks, Mr. Bala. Mr. Nikhil, you can start the presentation, please.
Yeah, thank you so much, ma'am. So as we all aware that today's presentation topic is on independent directors, their roles, responsibilities, and duties towards the good corporate governance. Basically, going ahead, I would like to throw some light on the evolution of independent directors in India. So basically, the corporate governance concept and the models India has adapted from US and UK. In 1996, Confederation of Indian Industry has introduced the concept of corporate governance, and they had certain debates. They issued certain notifications, circulars, writing ups, to promote corporate governance in India. Then in 1998, there was a important debate in that committee to issue and to introduce the concept of independent directors in the listing agreement. For this purpose, in 1999, SEBI set up a committee under the chairmanship of Shri Kumar Mangalam Birla to raise the standard of corporate governance in India. Then the corporate governance concept introduced in the listing agreement under clause 49. Then the major role of independent directors was also introduced in 2000, in the year of 2000. Then in 2002, the Naresh Chandra committee made the definition of independent directors more precise, and thereafter it was a continued evolved definition by Mr. Narayan Murthy. Then in 2008, the concept of age limit was included in the SEBI regulation, that the minimum age criteria is 21 for independent directors. By this brief history, I would like to start my presentation. Is my screen is visible to all?
Yeah.
Very much.
Please go ahead.
Yeah. Yeah. So basically, who can become a independent director? So there are two definitions, one which is under Companies Act and another is under SEBI LODR. So basically, as per Companies Act 2013, a person of integrity and possesses relevant expertise and experience can become independent director, who is or was not promoter or related to promoters or director of the company. So that is the second one. And the third is who has or had pecuniary, has now pecuniary relationship 2 years preceding financially, immediately preceding financial year, or during the current financial. So these are the basic three criteria which the independent directors individually shall own. And apart from these three criteria, the relatives picture comes in. None of his relative is holding security or interest more than rupees 50 lakhs or indebted to company more than rupees 50 lakhs. Then none of his relative is given guarantee or provided any security more than rupees 50 lakhs. And another one is any other pecuniary relationship or transaction more than 2% of gross turnover or total income singly or in combination with transaction. So basically the pecuniary relationship is also defined under the Companies Act. Then the last criteria is neither himself nor his relative hold position of KMP or employee in any three preceding financial year. But in terms of employee, I would say a person can be employee in company, and the independent director can be the independent director if the employee is relative of him. Then neither himself or his relative is or has been an employee or partner or proprietor or partner from firm of auditor, cost auditor, company secretaries, or any legal or a consulting firm has or had any transaction more than 10% of total voting power. Then neither himself nor his relative hold together with relatives 2% or more voting power. Then the chief executive, then neither himself nor his relative chief executive director of a non-profit organization receiving 25% or more of receipts from company, or any of its promoter director hold 2% or more of total voting power. So these are the criteria under Companies Act.
Just hold on. Just take to that slide only, Nikhil. I'll request the panel to comment on this because this is really a crucial, especially the first portion that as regards the integrity and relevant experience, expertise. What is your view on the topic in the sense that it's very subjective?
Yes, ma'am, it is very subjective because integrity is something you really cannot define or you cannot display. It has to be in your DNA, and then it is only reflected in the way you carry yourself or the way you behave. So most important for an independent director is that whatever, of course, the emoluments will come in terms of sitting fees, but not having any other monetary or pecuniary relationship is essential, which determines that he is not inclined towards agreeing or towards taking any call basis the benefits that he's deriving out of his directorship or out of his association with the board. The integrity, as I said, it's reflected how the person will be cautious or will be guiding the board in terms of taking a particular decision. The most important point I feel here is the person should be true to the benefit of shareholders rather than his own benefit or the director's benefit. So once the interest of investors or the shareholders is kept in mind, I think that's how the person will be able to perform his duties better. And the other part in the definition, I think it is more to identify or more to fence the kind of transactions which would identify a person to be related. While I think there are certain time period which have been prescribed, there could be a stricter view taken as well. Now, I think Companies Act, not much of such definitions or such statements will be looked at that critically. But when these kind of definitions come up in the listing regulations, and I think that point also will be discussed. But specifically, when the proxy advisors look at the independent directors, the independence of independent directors, they don't look at this definition strictly. So they will say that don't follow by letter, but go by spirit. And that is where it is more important that the person is truly independent, not having any kind of transaction or a relationship or a monetary aspect coming into place in that directorship. So I think that's what I will add at this point of time.
Yeah, in the case of this relative, it's really challenged because the relative definition is so vast. In one of my client only we had experience, the director was appointed as independent director. And then later on, he realized the auditor was Big Four. And one of the relative was employee of that auditor 2.5 years back, though that lady resigned. So he recollected, so he then mentioned that, oh, this is the position, what to do. I said, yes, that is there, the timeline is there. So what we done, then we make him not independent director, brought another director because it was odd on our part that we remove him. He offered himself to resign also. So we have to actually educate the person and ask specific question, tick mark whether this is there or not there, please check, give the relative, and then if we take it, that helps us that later on that person is not in our wrong footing, and you are also have different situation where you can't remove the person. So that then you have to add one more independent director and that entire composition get changed. So that's why I think we have to create a questionnaire before we appoint independent director. Please tick mark so that we can save all this.
Right. And as you rightly said, of course, this applies more for unlisted companies where the people need to be very much clear about the definition, who are not maybe more frequent with other boards. But I think this is a very valid point, be it unlisted or a listed company. This kind of a checklist to be placed before a director, before he submits his declaration, is a very good move and very important, so that the director himself is aware about each and every nuance of the definition as to where it could be an aspect of leading him to be a non-independent director.
Yeah, and of course, you know that because like we have to ask them that, this relative has not done and not done. So one of the question I received from one of my friend, he was appointed as he was supposed to be appointed as independent director. And he says, Dipti, I have to write that all my relative, but I am not in touch with them. They are overseas. I can't ask, it's really awkward for me. How to handle this situation? Many times this is also the situation. You don't talk or you are not in good relation with that relative also, but they are still your relative. So in that situation, I will ask this question to panelists, how to handle this?
So I think this is a tricky and challenging situation. But since it is, at least for the part that where they need to prove themselves to be independent as per the definition,
Right.
they need to speak to the relatives and get a confirmation, because it puts them into a jeopardy that while they have been confirming something that they are not very sure about, will lead them only to be non-independent. I think we have also had this kind of challenge specifically when we ask for the insider trading disclosures, and then they have to give information about the relatives, and they say that we are not in touch. Of course, as you said, they are overseas or they are doing their own business. So how can I ask for their PAN details or their personal details? So that's where I think to some extent, because the definition or the regulations say that only if the person is dependent on you for the financial decisions, then you disclose, otherwise you may not. We can advise to that extent. But when it comes to the definition of being an independent director, I think it's a humble but strict request that please speak to your relatives and get the confirmation, because it's not just for you, because your position as an independent director has other ripple effects on the company. So as you also said that if the person is non-independent, you have to bring in someone else as an independent. You have to ensure the board composition is met, the committees are properly constituted. So we cannot really risk any of the other aspects. So I think while it is difficult, but it is important.
In this scenario, I have actually stated that you write to them officially, mention that you are becoming director, write to the law requirement why you are needed this information. If you don't inform you, but at least inform the company, so the company can take a call. So the maximum extent, if a person does his efforts and then give the declaration based on the information knowledge he had and a communication had with all the relatives, he is independent. I think he is taking extra sufficient care. And when the person has taken all the care and declare everyone, and then taking the position and declaring the same thing, I think the person, as we have also discussed earlier, and you rightly mentioned, Vallari, that it is the peculiar nature of that person who should be acting independent.
Actually, yes. So even in one of the previous cases when we had a similar situation, yes, the person had through his legal counsel approached the relative and then sought the information. So when he was not on talking terms, he put his legal counsel, put all these details, and then the legal counsel got the information. But as I said, it was a humble request that you need to get that confirmation, because ultimately it not just impacts you, but impacts the company as well.
There is a question in the chat box. Can a person holding 2% or more shares of ultimate holding company, which is not direct holding company of the listed entity, be appointed as independent director? As per the LODR provision, person shall not be associated with or not, I think, holding the shares of listed entity, holding company, subsidiary or associate company. Ultimate holding company may not come under this provision. Vallari, your view.
Good question, but ultimate holding, I believe here will be part of the promoter group, because when you are saying it is holding of the holding company, though it is not in the definition, it is part of the promoter group, and then you cannot exclude it. So it will have to be considered.
Spirit of the law.
Yes.
I think in this particular case, the law has to be interpreted strictly. If the law says company, it is company.
That is all.
Otherwise,
That is all simply.
Huh?
I agree with you, sir. Why it is a wider interpretation? We cannot say it is not mentioned in the law, so it is exempted. No, you are right.
No, from the point of view of corporate governance, etc., one could do that. But if you're strictly speaking from the point of view of law, then what is mentioned here is 2% in the company. it doesn't mean, it doesn't say anything about subsidiary companies, holding companies, whatever one. And here the question is going into ultimate holding company. That is still worse. I think one did not interpret it that strict.
No, Sailesh bhai, he is talking about listed company. In
Yes.
LODR, he will not be associated with or holding the shares of the listed entity, holding company, subsidiary or associate. That all is covered. But
Oh, I see.
holding company,
Ultimate holding company is not.
it's not covered.
The word ultimate holding company is not there, but all other things are all there. Subsidiary, associates, everything is there. Only ultimate company is not.
Sorry, I was not aware of the listing part.
No, he has written.
But still, you will go strictly by what is there.
Yeah.
I would not extend it to something which is not mentioned in either the act or in the listing regulations.
Liberal interpretation, strict interpretation.
I would not take a liberal interpretation. I would take a strict interpretation and leave the liberal interpretation to the person concerned and his views and about corporate governance.
Yeah, it is the
Hello.
panel. Yeah, please.
Yeah, hello. Can I ask question? I'm Jivan Mondkar.
Yeah,
Hello. Good morning, madam.
Good morning, Jivan.
Nitya, madam, and good morning to all the panel members. I am Jivan Mondkar. Currently, I am serving Wokhad. So I have one question about the integrity and experience and how the independent director should really display their integrity, because recently there have been reports where, you know, in the media where independent directors was not shown in the good light. Recently there was some reputed company delisting offer failed, and to be specific, I'm coming to the point, Vedant Limited, where no, there was a report where independent directors could not show cause and could not present their case to the board and couldn't act in the interest of the shareholders. It happens quite a lot in the, especially in the promoter driven companies, where, you know, independent directors just go with the flow of the majority of the board members. So we as a company secretary, how we can give a comfort level to the independent directors, pinpoint where they feel that there is some fishy, where they feel that this is not a proper in the interest of the shareholder, they have to show their spine and take the charge and oppose the matters. So how we as a company secretary can give the comfort level to the independent directors?
Yeah, so yeah, I understand independent directors a lot of times depend on company secretaries for getting the regular information about what's happening in the company or how things are going on. So first and foremost thing is, whatever information that you are sharing through your board agenda, make it as transparent as possible so that the independent directors can understand what is the matter being put up for their discussion, for their decisions. And if they have any questions, they can raise those questions, which the management is supposed to answer. So that's the first thing that we'll follow. Second is, it's essential that the independent directors also need to connect with the finance head or the CFO and have a meeting independently to understand about the financials beyond what is discussed at the board meeting or the audit committee, because maybe there are limited aspects that could be presented or the ultimate discussions which are presented at the committee meetings. But it is often essential that the independent directors, if they sense a particular matter or a particular thing going wrong, they should on their own connect with the CFO and get the financial information. They can very well connect with the company secretaries and also ask for relevant information. So we have had situations where the independent directors do probe about the internal audit aspects, the internal audit queries that have been raised. If there are any concerns or any complaints raised, they ask about how it has been resolved, what exactly has been the process followed. So this is expected from the independent directors, and it's your duty to give that information wherever it has been asked for. That's how you can give them comfort. I think for them, the first and foremost aspect, as I said, is the board information. So that's where you can connect with them. And they have not been any time prevented from connecting with you other than the board meeting. So if you speak to them and if you tell them that we can, of course, have a detailed discussion on any of their queries and concerns, I think that they will get that comfort of understanding how the matters are going.
Very valid point.
Okay.
And always independent director get connected, and there is a tendency of an orientation program. Always you can educate them And they at the end always ask about CS, have you ensured compliance, and CFO, you ensure compliance, anything you want to add and anything. At that time, basically CS can give the facts and the law. Now that interpretation, that independent director is required, they can dig out the questions. So that is the duty of independent director, but the present the facts in the way and in transparent way which gives the meaning, and we need not twist it out what the word is. Then it gives, as Vallari rightly mentioned, in transparent way, that gives the idea. Yeah, there is a,
Thank you.
welcome. There is a question here in the chat box. Independent director says the relatives are reluctant to share information how to handle such situation. I mentioned, and panel also mentioned how to handle it. Prasanajit Guha, is the cooling period applicable to the independent director adequate? As many times in practice we have seen the heart of independent director lies with his previous company where he was in full-time employment. Panel.
See, now we cannot determine where the heart of the person could lie. See, the cooling off period is essentially for him to disconnect with the relationship that could make him non-independent. So it is by the definition, if he has to be independent, he should not have any ties with his previous employment that you have mentioned. So from whole time to independent. Now, interestingly, if you see the latest amendment that has come in the listing regulations, even an independent director who resigns and is proposed to be taken up as a whole-time director in the same company, its subsidiary, associate, or a promoter company, even there the cooling off period is provided. So maybe the regulators think that at least there is some time given for them to disengage from the earlier association and then wholeheartedly take up the new association. But essentially the idea of cooling off period is only to bring that disconnect between the relationship, between the transactions, or between whatever his mode of thinking or mode of behavior has been, and to get into the new role afresh.
Right. The next question is, if son-in-law is part of company conducting internal audit, then independent director criteria will get impacted or not?
No, I think it is the auditor, meaning only the statutory auditors. Ma'am, if you have any other view, I don't think internal auditors are covered here.
Yeah, very intelligent question. Yes, the same way what we discuss about holding company and ultimate holding company. But here, internal audit, they always say that auditor, the statutory auditor. But take it spirit, because what happens that I will say that way, that if we take liberal view, it will put in the problem that director and company in the spot as well. Because later on, if anything happens, what happens that we give more chance, we are more vulnerable to the wrong situation in that scenario. So given the situation, if it can be avoided, I will say yes, technically you can. But practically we are opening, little, we are more vulnerable to the situation where it can be questioned. Tomorrow, if anything happens, then it says that yes, that conclusion is very easy from the regulator point of view. That's why I will.
Dipti, letter of law, fine. Spirit of law, no. That's it.
Yeah.
But ma'am, I think, I will add to this. And what you said is, these days, I think why companies are taking a conservative view is because the way the regulators are dynamic, the way the amendments are coming, the way they have been interpreting, and many a times we have seen that they are giving even the retrospective effect to certain transactions, which again is putting everyone at risk in terms of the conduct of business and compliance with the law. And that is where I think while we are looking at the letter of law, we do go by spirit, or rather I say sometimes in a conservative way while taking a decision.
Yeah, because the company's name get, image get spoiled by this small things. There is another question, but not considering the conflicting interest in ultimate holding company, would such, we are talking about ultimate further question, but not considering the conflicting interest in ultimate holding company, would such the independent director be independent in his judgments? Now that's why only we are talking, Mr. Virendra, that whether we should or not. So it's again the facts of the case. Better we take conservative view, and then we also said that we will prefer conservative view. Spirit, as Mr. Bala mentioned, spirit of the law. Okay, I think enough discussion and we can move ahead. Nikhil?
Yeah. So we have discussed the definition as per Companies Act. So the independent director as per CBLADR, there is a definition under Regulation 16. Independent director means a non-executive director other than a nominee director of the listed entity. Then who is, in the opinion of the board of directors, is a person of integrity and possesses relevant expertise and experience. Then who is or was not a promoter of the listed entity or holding subsidiary or associate company. Then who is not related to promoters or directors in the listed entity, its holding subsidiary and associate company. Then who, apart from receiving director's remuneration, has or had no material pecuniary relationship with the listed entity, its holding subsidiary or associate company, or their promoters or directors during 2 immediately preceding financial years or during the current financial year.
Yeah, I think Nikhil, I would like to add a few points in the listing. I mean, in the definition of independent director as per listing regulations, and one which was there, I think, in the 2015 regulation itself, that the person should not be a customer service provider, lessor or lessee. So while of course with any of these transactions there would be a monetary angle included, but it has been specifically prescribed. Second aspect which got introduced because of the 2018 Uday Kotak committee, and it's quite interesting. It's called the board interlock. So it says that the non-independent director of another entity on which the independent director of non-independent director of this entity sits as an independent director cannot become an independent director. So this, I think, is an interesting point which was brought in 2018, effective 2019, when the Kotak committee recommendations were prescribed. So for the audience, maybe I can practically put this in the live example that we have. So Mr. Harsh Goenka, who's our non-executive chairman, he's the promoter and he's non-executive, non-independent director. He is independent director on the board of Bajaj Electricals. So Mr. Shekhar Bajaj, who is again the promoter and non-executive, non-independent director of Bajaj Electricals, is then by definition non-independent. So he cannot be independent on CEAT Limited. So that's called a board interlock, and it used to be a very common situation. I think there's been a lot of research done on this, that many times two friends will come together and say that I'll be independent director on your board, you become independent director on my board, because you strictly fit in the definition. There has been no other monetary transaction, there has been no other relationship, but just because we are friends and we could accommodate each other, we could then help each one on the business, and this has now been disconnected. So this is, I think, interesting to know that now you cannot have such kind of a board interlock for independent directors.
Okay, thank you. Yeah, Nikhil, go ahead.
Very nice point, Vallari. Very nice point.
Yeah.
You had some difficulty with this as a company secretary?
No, so I mean the example that I gave was to explain that Mr. Shekhar Bajaj cannot be independent director on our board. In my organizations, wherever I work, we have never had this kind of.
Yeah.
So the next point is manner and selection of independent directors. As we all are aware of the recent amendment that every individual who intends to get appointed shall apply online to the Institute of Corporate Affairs to include his name in the data bank for 1 year or 5 years or a lifetime. After the included shall submit a declaration of compliance to the board. Then one's name is included has to pass online proficiency self-assessment test conducted by institute within 2 years from the date of inclusion of his name. Failing will result in removal from the data bank of the institute. Moreover, score of at least 50% of deemed to have passed percentage of the test. And the next thing which is about manner and selection, there are certain criterias and the individuals who are not required to give such online proficiency test. An individual not required to pass online proficiency test if he served for the total period not less than 3 years as on date of inclusion. And if such individual is a was a director or KMP in listed company, so that is the first criteria. Unlisted company having paid up share capital of rupees 10 crores, then in body corporate of listed on any recognized stock exchange in a country which is a member state of Financial Action Task Force. Then bodies corporate incorporated outside India having a paid up share capital of US $2 million or more, or statutory corporation set up under an act of parliament. People like director can be not required to give this online proficiency test. Then the second exemption criteria is the individual in the pay scale of director or equivalent or above in any ministry or department of central government or any state government and having the experience. And the third, in the pay scale, if an individual is in the pay scale of chief general manager or above in SEBI or RBI or IRDA or the pension fund regulatory and development authority, and having experience in handling the matters relating to corporate laws or securities laws or economic laws. While the recent amendments, the individuals who are or have been for at least 10 years of part of profession of an advocate of a court or in practice as a chartered accountant or in practice as a cost accountant or in practice as a company secretary shall not be required to pass the online proficiency self-assessment test. So that is recently brought in. Shall I move it?
No, Nikhil,
Yeah.
in this you're saying not less than 3 years as on date of inclusion. That means it can be even 10 years prior, is it? That means in 10 years prior, if I had been a director of an unlisted company with capital of more than 10 crores, that's okay for 3 years, but 10 years back. That means Purana Admi. Or is it 3 years preceding the date of appointment?
Not less than 3 years as on date of inclusion means the case you are saying would work.
Like for I have been director in the years 2004, 5, 6, 8, but that is not relevant any longer. I should have been director in the year 17 to 20, something like that. What is it, Vallari? With
yes, the understanding is that it should be the recent engagement with the
yes.
company. Yes.
But the law is not saying that.
Law is not saying that. But
Yes.
what is expected is the recent one.
It is expected that it is recent because so you know what the law is, etc.
Right. Right. And in fact, again, to add one practical aspect to it, while this is the exemption which has been given, it is for company secretaries quite challenging to help the technical persons or technical people who are being appointed as independent directors who don't really know much of the law. So again, one practical aspect, what we have done is we have prepared a deck which can be helpful for the independent directors to understand what are the applicable laws, what are the regulations, what are their roles and responsibilities, and maybe certain aspects about Companies Act where they should be aware of. I think that can help them go through that and appear for the exams. But yes, I think for them it's a bit challenging, and for you also to take up that kind of session with people of high stature, but of course they are expert in their own field, but they need to understand about the legal aspects to complete this exam. So this is one challenging aspect. Now, I have had a limited exposure on talking to people who would need to appear for the exams, because most of the directors that I've interacted with have had at least 15, 20 years of experience of being independent directors. But yes, this is one aspect that I think we all should take care of, how to help the any person newly being appointed as independent director, someone from the technical background, and then to appear for these exams.
And Schedule 4 will help considerably in this, no? Because now Schedule 4 lists out their requirements, duties, etc.
Yes, it lists out, and that is where what is as a practical tip for company secretaries is to make a combination or a compilation of all such information, which the director can go through and then appear for the exam. So it becomes like a easy Bible or a reference for an independent director about the statutory provisions and the roles, responsibilities, and other aspects. Now, I don't know about the exam, honestly, if there could be more questions around the Companies Act provisions, but this is the basic thing that we have done for the independent director.
Yes.
But I also put that way that, yeah, it is taken very bad, taken that why we should be given exams and all that. But I have come across certain directors before exam also, they were very clear that what is my responsibility, what is expected from me. And rather earlier also I used to, and it is the duty of CS to explain the director what will be his responsibility. Unless and until, because before exam, unless we explain them their duties and responsibility, forget rights. Rights is the minimum. When you are director, there are a lot of duties and responsibility and expectation. And when you are independent director, it is more so. And what is that position, what the law expect, what the regulator expect, what public expect. If we explain them, then they look at this knowledge. Exam is next step. They will understand the importance of having this knowledge. And really, yeah, CS, there will be CS who will say that it is easy to say, but it is difficult. But you have to convince the director, and slowly and steadily they accept that yes, I should know that what I will be in problem. Give the decided case example, which is very common in the newspaper. Then you have to make the person ready for the requirement of knowledge, then exam, then it becomes easy. There is a question, company A is a listed public company, company B is unlisted private limited company. There are no common directors between A and B. A is not shareholder in B and vice versa. Individual C is independent director in company A. Individual C is a statutory auditor of the company B. Can we say that company A and B form part of the same group? Is there conflict of interest on the part of individual C, and would the audit firm be required to resign in company B as a statutory auditor? Means there is no connection between the company, but one independent, in one company, a person is independent director. In another company, he is a statutory auditor. Whether they are in the same group?
Not at all, because he is serving as statutory auditor on the private limited company, while being independent director on a listed company. There is absolutely no shareholding or no common directorship or no purpose which is common for company A and company B. which can make them part of the same group. So there is absolutely no connection here.
And when you are auditor, you are in a professional capacity. That is also to be noted. The position is on a professional capacity.
Yes.
And the next, is a C or CS with 10 years or more experience in industry or BFSI required to pass self-assessment test? It is no, it is written here down.
Now the exemption is for experience over 3 years
Yeah.
as a professional. So
Yeah.
that's exempt.
Yeah.
Dipti, I think there should be an amendment to this rule about 3 years. It should be 3 years in the any 3 years in the preceding 10 years or preceding 7 years. Something like that should be
Some
brought in.
timeline, because law is changing so
Law is
fast.
changing so much. 3 years within the preceding 8 years. I think if any reference comes to the institute, I think we should ask for this change.
Otherwise also is, sorry.
Now, for example, I am qualified without any exam, but I did not know that the requirement of independent directors in listing companies. That is wrong.
See, Vallari is so educated and knowledgeable, but is
No.
compelled to accept this in an open session. Very rarely you get this kind of honesty.
No, nothing like that.
Yeah.
Absolutely, sir. It's actually so. If you rightly say, there are two aspects of this exam.
Yes.
One is, of course, the technical aspect of the legal provisions or the statutory provisions, and second is the experience of that person that he brought and brings in on the board.
Right.
So, while as you are humbly saying that you would not be aware of the latest points, I would not agree with that. But with your experience, I think this is essential. An exam, I think it's more for those who are newly entering and understanding the entire gamut of being an independent director, or especially for listed companies that be so applicable, and even for unlisted companies wherever because of the certain threshold is becoming mandatory. The entire intent of an independent director is to protect the interest of shareholders, and hence they need to be aware of the statutory provisions. But maybe this is a valid point we can take up and understand.
Yes.
Rather than putting up as a representation, let's have a clarity from the government if what is intended and what is expected.
And I will put it that no need to clarification according to me, Sailesh, because see, you need a kind of certain liberty in selection. With this, some relaxation is available, because many times the people are not ready, and he has well experienced that earlier. Then that person company get liberty.
Bala, is this exam difficult? Have you seen any paper, any?
But Sailesh, no, I have given myself.
Why you have to give your company, say, practicing company secretary?
No, that time exemption was not that. There are a lot of rejection, registration. That's why later on it came.
Okay.
Okay, and giving exam is something people are so busy and they have to give its pain. They say, I am not interested. So many directors resign.
Correct. But no, my question is, Dipti, was it a difficult examination?
For us, it will not be, but you have to read, no, any exam.
You have to read.
Yeah. It's not 3. The question is, it's not 3 immediately preceding years. It's open. It's with respect to minimum experience.
Okay, sorry.
Right. And I think one point, ma'am, which all the company secretaries will agree, that now with the entire dynamism of Companies Act and the listing regulations or the SEBI regulations, so to say, the way the act or the law is changing every day, it's essential to read whenever there is a need. So it's not so easy that we know the provision, but ultimately when we have to apply it, it's better we read it again with the circulars, with the clarifications, with the notifications, because there are so many aspects around it.
Yeah. Thanks. Nikhil, you can go ahead.
Yeah. So there is a requirement of appointment of independent directors under Companies Act. So under Companies Act, the definition under 149 says that every public listed company shall have at least 1/3 of its total number of directors as independent director. And the another one is about every public company. So every public company having paid up share capital of rupees 10 crore rupees or more, or having turnover of 100 crores rupees or more, uh, and or which have in aggregate outstanding loans, debentures and deposits exceeding 50 crore rupees. So these are three criteria, and such public companies shall have at least 2 directors as independent director. And under this section, there is an exemption for unlisted public companies. That if first is a joint venture, wholly owned subsidiary, and the dormant company defined under section 455. Shall I move ahead?
Yeah, please.
So what is the procedure of appointment of independent director? So while appointing an independent director, such director should be a qualified director. Of course, he should acquire the DIN. Such individual shall acquire the DIN. Then he shall ensure the inclusion of name in the independent director data bank. If he has a relevant experience in the past years and he fulfill all the criteria of this data bank, then there is no need of separately inclusion of name in ID data bank. Then the recommendation of NRC to the board for such appointment. NRC shall recommend the appointment of such individual as an independent director to the board. As per a recent amendment, the NRC shall evaluate the balance of skills, knowledge, and expertise of such proposed independent director and prepare a report slash description, and the same has to be disclosed to the shareholders while recommending the appointment in general meeting. Then such director has to give the consent to act as a director. Then the declaration of independence and appointment in a board meeting. Then post the board meeting, such independent director will be recommended for appointment in the shareholders approval. As per recent amendments, it should be the next AGM or 3 months from the board meeting of appointment, whichever is earlier. Now, it cannot be said that he will get regularized or he will get appointed as independent director post his appointment of director in next AGM, but now it should be done within 3 months or the AGM, whichever is earlier. Then there is another amendment that the special resolution shall be passed at every appointment, that is first and or for second. Previously it was for the first appointment it was ordinary, and for the second it was special. Then post the appointment in the board meeting or AGM, there should be an intimation to the stock exchanges under regulation 30. And there should be an intimation to the post appointment within 30 days from the board meeting as well as in the AGM.
Vallari,
That is the brief process.
yeah, your comment on the recommendation of NRC as per that you have to evaluate balance of skill, knowledge and expertise.
Right. So this is a very latest amendment. It has come into force from January 22. So practically, I think companies will now experience how exactly to implement it. But essentially, this links with the previous requirement put up by the Kotak committee to identify the skills and metrics for the board members and display that in the annual report. So once you have identified that for your company and the industry that you belong to, these are the few skill sets which are required from the board members. And then you identify who possesses a certain skills so that you know where is the gap. So a particular skill may be or may not be available with certain set of directors. And then essentially, then it is linked as to when you now appoint a new director, you will identify what is required, what is missing, and how will you balance by appointing the new director with the available or the applicable skill set. So that's how I think I'll link both of these requirements, one introduced earlier and one introduced now. This is becoming more like a regular recruitment process where you identify what is the job description, what is the role requirement, what will you expect from the person, and then identify the person suitably. This is also bringing in one aspect of choosing the right person from the professional data bank or from the available information of skill sets, rather than in most cases, which happens is people being chosen as independent director basis just their experience with different companies. So I think this will help sharpen the entire skill set of the board, and it will have a very good balance mix of the skills that are needed. So not just the technical skills, but there would be legal aspects, there would be financial aspects, and there could also be public policy relationship, international business. I think many of such skills which are needed by the business. It is not just the industry specific skills, but these are other skills also that can be brought in by the board members.
Vallari, I would think actually the days to come, probably the whole recruitment procedure of the independent director will be moving to the independent agencies rather than only with the committee people. Because all the committee members may not be well versed with all the things of the business. Somebody may be good at finance, somebody may be good at marketing, somebody may be good at some technical. But the thing is, probably the days will come. Probably it will move to the, taking the independent expertise in the recruitment process. That is where it will move, I think so.
Right, sir. I think if I'm not wrong, NRC is at this point permitted to engage an independent agency to get the recommendation.
Yeah, they are permitted, but I am thinking in the longer run, it will happen like that. Because probably what will happen is they will engage the independent agency who will actually shortlist and present to the NRC, and probably NRC will select one of the shortlisted candidates after the independent expertise exam. That's what I think.
Right, sir, which is very well possible because the agency will only help you shortlist or identify people based on the skill requirement that you have.
Yeah, the recommendation will happen by NRC, but the independent expert will actually identify what are the things when it comes to the skill matrix and requirement, whatever the things suits to the organization, etc. That's what I would pursue. Yeah.
Yes, it is, Mr. Bala, it is in the place. Actually, there is agencies and they are doing it. They are getting this profile because I am also contacted by them, and they literally have the profile that what they look for and what kind of knowledge, experience it is there, and then they recommend to NRC the various things they go through, and then they give it to the board. And with this now different skill, technocrat and HR knowledge and international relation and public relation, lot of
skill sets.
Yeah.
Achha, don't you think, Vallari, here the 3 months regulation is applicable to the listed companies, whereas the unlisted public companies can wait for 6 months? 9 months.
Yes, in fact, this point is applicable only for the listed company specifically.
Yeah.
And just again to highlight a practical aspect, this amendment came in August 21. So to be precise, 3rd August 21, this amendment was notified by SEBI. Now, while it was in the board meeting outcome of SEBI that these are the proposed amendments to be made effective from 1st January, the amendment on 3rd August did not specify the effective date of the new provisions. And it created kind of a panic and chaos amongst the companies who had proposed their AGMs between August and September, who had already appointed their independent directors previously for almost more than 3 months, 6 months. And then there could have been a possibility of non-compliance. Thankfully, I think SEBI realized this, and on 6th of August, SEBI came out with a clarification that the entire amendment should be read as to come into effect from 1st January 22. So this is how it happened in the last year. And when now Jan 22, it was to be again implemented. A few days earlier, the stock exchanges issued a clarification that this time period will apply only for the appointments being made post 1st January, because again, companies were taking a conservative view for whatever independent directors appointed in the previous period take their appointment to shareholders by postal ballot within that period of 3 months. So I think SEBI also needs to be little clear with the expectation of implementing a new legal provision. We have also recently seen with respect to RPTs, the implementation was effective 1st April and then the clarification started flowing. So we know that's a bit challenging, but that's where I said that as company secretaries, why we are taking conservative view these days is because we don't know exactly how the regulators will look at it at a later point of time. And there we will not have a time to go back or do any corrective measure.
Not only that, in case of the appointment, again, listed company record the special resolutions.
Yes, this is now
in case of the company side, appointment doesn't need the special resolutions.
Correct. This is also a new requirement that for any appointment or reappointment, it is special resolution. So correct. Unlike the earlier situation where the first term could be with the ordinary resolution, now it is required with the special resolution.
Yeah, the question Mr. Ramana has clarified that why I asked that exemption for CACS is
yes.
That with 10 years or more in practice, but it is not clear whether it is applicable to person with experience in industry in various senior position. I think when it is not there, we can take liberty, Mr. Ramana, that with 10 years post-qualification experience, it's on you how you take it. It's not taken, you take your conservative view and give the exam and be eligible. Being it is, I will say that again, we are talking spirit, being a director, again, independent director, let's take in spirit. And if you are not that kind of well-versed, better, we as a professional should give exam. Panel, your view, please.
I think this is interesting and it is subject to interpretation as to whether a person in the industry or in the organization would qualify for the exemption or not, or could be expected to be aware of these provisions. I think, as you said, it is not practice as an only person engaged in practice, but it's the post-qualification experience of that person which could be relevant. But I think given this question, which is quite interesting, I think we should have this checked with IICA or on their portal itself. If someone tries to register, how do they exactly respond with the kind of information being given as to person engaged in that industry for a period of over 10 years?
Can we go back to that slide? I think it was quite clear in that only practicing. Just go back to that slide, please. Yeah, where is it?
Yeah, here. Yeah.
The individuals who are or have been for at least 10 years part of the profession of an advocate or a court, or in practice, the word is there, or in practice as a chartered accountant.
This is what is written, and what may be intended is person having that experience. So I'm also not concluding that it is only this way or that way. I'm saying probably we can recheck this with IICA. I think this has been an interesting question. Sorry.
No, Vallari, here I'm pretty certain that the use of the words in practice, and so they've used it thrice. They've used it with everybody.
Only practicing.
Only practicing, only Dipti and not you and I.
I think the reason may be, I don't know, that whatever that if they put it in organization, then in organization your position and your exposure may be different in as such. But when you are practice, you are into that practice only.
Yeah. And you.
But it can be different also. It's not necessary I practice, but I may not actually work for that. I may work for some other reason. The same way like an organization. If I'm in a practice as a company secretary, but actually I'm not doing that much kind of work, and I'm involved in various other advisory. Then
I would not go into that at all, Dipti. I'll just go into the word of law. Practice. Yeah. The word practice is there. Otherwise, they would not have just said or is a chartered accountant, cost accountant. They would not have used the word practice. Then whether he has any practice or does not have practice, only holds certificate of practice. No. Yeah. You go by the language here.
It's a practicing profession.
Yes.
Yeah. Okay. Yeah. Thanks, Elizabeth. Yeah. Thank you, Mr. Ramana, for raising such an interesting question.
Yes.
Yeah. So post the appointment of independent directors, there is a important aspect that is appointment letter of independent directors, and what should be the pointers which should included in the appointment letter of independent directors. So that varies companies to companies. What should be the part of appointment letter, but yes, across the industry practice, these are the common points which I searched. The term of appointment.
Not industry practice, you are telling as per Schedule 4.
Yeah, yes. The term of appointment, the expectation of board from the appointed director, the board level committee in which the director expected to serve, and its task, the fiduciary duties that come with such an appointment, along with the accompanying liabilities. Then the provision for directors and officers insurance, if any, uh, the code of business ethics that the company expects its directors and employees to follow, the list of actions that a director should not do while functioning as such in the company, the remuneration part, mentioning periodic fees like sitting fees, reimbursement of expenses, then the participation in the board and other committee meetings, and profit related commission, which should be as per section 197, of course. And an independent director shall not entitle to any stock options, and may receive remuneration by way of fee provided under section 197 subsection 5, reimbursement of expenses, participation in the board meeting, and other profit related commission as may be approved by the members, that is prescribed under section 149 subsection 9.
I think one practical aspect to add here, when we had the appointment of independent director and Form DR 12 was to be filed after the board meeting, we were insisted to add the appointment letter. But since the appointment letter would carry the confirmation of appointment by shareholders and the term thereafter confirmed, we were of the opinion that the appointment letter would be issued subsequently. And so we filed the form with board resolution and it was accepted. So then it wasn't questioned by ROC. So I think this is something maybe members can throw some light what has been their practical experience or maybe thought around this.
Thank you. Thank you. Yeah, Nikhil.
Any members' experience on this? What Vallari raised the point? Anybody has the practical experience on this appointment letter?
All right, Nikhil, I think we can move forward.
Okay.
Yeah. So this is regarding tenure of independent director. An independent director shall hold the office for a term up to 5 consecutive years, but shall be eligible for reappointment on passing a special resolution by the company, and disclosure for such appointment in the board report shall be given. Then no independent director shall hold office for more than 2 consecutive terms, but such independent director shall be eligible for appointment after expiration of 3 years, that is cooling period of ceasing to become independent director, provided he shall not during the said period of 3 years be appointed in or associated with the company in any other capacity, either directly or indirectly, which is mentioned in section 149 subsection 11. So what are all all declaration required from independent director. So apart from the declaration required under section 184, that is a DR 8 and MVP 1. So these are two declarations required. So first is declaration of independence, section 149, subsection 7. Every independent director shall give a declaration that and shall state that he is meeting the criteria of independence as provided in subsection 6. He shall give such declaration at the first meeting of the board which he participate as a director. Thereafter, at the first board meeting in every financial year, and whenever there is any change in circumstances which may affect his status as an independent director, then the second declaration, which is of course applicable to listed companies, declaration under companies prevention of code of prevention of insider trading. So in this case, he has to submit three declarations. First is initial disclosure after his appointment as independent director. Then every year, that is annual disclosure under insider trading code at the beginning of financial year. Specifically, the annual disclosure period is not mentioned in the insider trading code. That could be a part of discussion. Then the third point, whenever there is any change in information, it should be submitted. That is what is the change, and that should be promptly informed.
I think, Nikhil, because since initially you give an as and when changes happen, you have to give, that's why they are not made annual disclosure. Because then it becomes too much, because any change you have to immediately do it, no? That's why.
Yeah, but for annual disclosure, which should be submitted every year under insider trading code at the beginning of the financial year, but the exact period of is not mentioned anywhere.
Okay.
Within 3 months or within 6 months, so that is not mentioned.
So I think one aspect again to add for the listed companies, and which was brought in by the Quota Committee recommendations, unlike the Companies Act where the declaration is given by the independent and which is taken on record by the board that the person qualifies to be an independent director. For a listed company, apart from this declaration, the board is required to conduct a veracity of that declaration and affirm that the independent directors are truly independent. So while giving the declaration, apart from the definition, it says that if the director is aware of any facts or circumstances which may lead him to be non-independent, he is supposed to disclose that. And the board is not supposed to just take the declaration, but conduct an assessment of veracity and ensure that the person is truly independent. So I think this is also practically a tricky and challenging aspect.
75,000 से लाख रुपए हो जाएगा.
स्ट्रेस एसेट वाला है खाली, इसके लिए ओपन ऑफर नहीं है.
अच्छा, वो exempted.
वो लिखा है ना उसने इधर. रेजोल्यूशन पास स्ट्रेस एसेट डायरेक्शंस 2019. इसमें वो वैल्यूएशन रिपोर्ट और वो कुछ भी एप्लीकेबल नहीं है.
विचारेगा.
Excuse me, I think Sanjay, you required to be mute.
He's muted now.
Yeah, okay, thanks.
Yeah, sorry. So I was just adding this, that for the listed companies now, this is an additional step and aspect while taking on record the declaration of independent directors, that they also need to conduct this assessment that the directors are truly independent.
Yeah. Thank you, Vallari.
Then the remuneration of independent director, section 149 subsection 9. So under Companies Act, section 149 prescribes an independent director shall not at any time be entitled to any stock option and may receive remuneration by way of the following three things. First is sitting fees under subsection 5, section 197. The directors may receive fees for attending meetings, that is sitting fees of board or committee, and such fees cannot exceed rupees 1 lakh per meeting. Then sitting fees paid to independent directors and women directors shall not be less than sitting fees payable to other directors. Then the reimbursement expenses for participation in the board and other committee meetings. And the third one is profit related to commission as may be approved by the members.
There can be question whether sitting fee of independent director and woman director can be more than other director.
Can be more.
Interpretational, yes. If you say it should not be less, but it can be more.
More, yeah, it can be more.
That exactly the question from Mr. Ankush. Can sitting fees be paid different for two independent directors?
In fact, interestingly, again, the Kotak committee had certain recommendations of payment for independent directors, and they could be linked, and there was a suggestion for higher payment rather, so that the kind of responsibility the independent directors are taking up, they should be remunerated well for those responsibilities. So maybe it was again a debatable point where not to lead that to a pecuniary angle, but also to ensure that their risks and responsibilities are covered well. But, so far not implemented, I guess.
But does this mean, Vallari, that the sitting fees for a woman director and an independent director will have to be the same?
It has to be the same, or interpretationally, yes, it can be more, but certainly it cannot be less.
No. It cannot be less than other directors.
Correct.
But between the two of them, say their fees are more than that, sitting fees are more than that of other directors, but between an independent director and a woman director, can an independent director have more fees, sitting fees than a woman director?
Silent boy, interestingly, SEBI has brought an amendment. There has got to be a independent women director to be appointed.
Oh, agreed.
Yeah, earlier it was women director.
Yeah.
Now the women director is also to be independent women
There has
director.
to be one independent woman director. Agreed.
Yes.
But Bala sir, I think this aspect is coming up from the Companies Act. So with respect to Companies Act, you will not have a woman independent director necessarily. You can only appoint a woman director on the board, and there could be independent directors, and hence this question is valid. Between the independent director and woman director, can you have a different sitting fees payable? Interesting, but honestly, I don't know if practically that's to be answered.
As on today, I think no prohibition, but it can be taken wrongly by as a woman empowerment. That is to be kept in mind. And the same way, the question raised by Mr. Ankush is that can sitting fee be paid different to two different independent director? As on today, there is no provision, so I think yes.
Yes, so long as it is more than that paid to the other directors.
But the criteria and then how the other independent director take it and all that to be seen as such. Yes, but it is possible.
I have one more question, and this is a little philosophical. Why is it that stock options are denied to the independent directors? What is the logic?
So the logic, logic per se is stock options is nothing but your shareholding in the company, your involvement in the company, which could then lead to the definition where a person is not supposed to hold any stake. Now, of course, there is a limit of 2%. You can say that stock options up to 2% could be exempt and the person could still hold shares. So there is no prohibition for an independent director as on date also to hold shares. But the nature of stock options being such that it is a futuristic commitment for holding stake in the company basis the performance, basis the other whatever criteria that could be provided. So essentially it works well for the employees who are to be retained in the long run. Do you really need the independent directors to be lured by such kind of long-term incentives is one question. But that is where I said the Kotak committee had a recommendation for even stock options for independent directors, but it is still being debated whether it is whether it's a good option or not, and hence it is still not permitted.
You know, this
could be argued both ways. It could be argued both ways. It could be a kind of real incentive for the independent directors to
Yes.
help the business grow and could be linked with, of course, profits. But it could also mean that they are being asked to stay for a reason which is in the future, and then if that that blurs their decisions or affects their independence. I think it's argued both ways.
You know, this thing I think came some time back when there was a nominee director of a financial institution on a company. I will not name either of the two. The company issued ESOPs, and they were issued to all directors. This nominee director of the financial institution got the ESOPs and he kept them to himself. He did not pass them on to the institution. I think it was after this that these things started, because he's a nominee of the financial institution. Whatever sitting fees he gets, he's supposed to hand over to the financial institution. Similarly, ESOPs that he got, he should have handed over, but he kept it to himself. And then such thoughts started coming in.
Okay. Okay. Thank you. Nikhil, go ahead, please.
Ma'am, before he starts, if you can just excuse me for a minute, I need to get my charger plugged in. Just
Yeah.
you can start.
Yeah, yeah.
Yeah. So the composition of board of directors as per SEBI listing obligation disclosure requirements. So as per regulation 17 of security of SEBI LODR, the composition of board of directors in a listed company shall be as follows. The board of directors shall comprise, so the wordings are exact from LODR. The board shall comprise at least one woman director, at least 50% of total directors shall be non-executive directors, and further, while the recent amendments, top 1000 listed companies shall have one independent woman director on the board of directors. Then with respect to the chairman, the board composition changes. If the chairman is non-executive, regular non-executive director, then the 1/3 of the board shall comprise of independent directors. And as per recent amendment, if chairperson is non-executive director and related to promoter, or is a promoter or related to person occupying management position, then in that case, at least one half of the board shall be the independent directors. Then in case a chairperson is not regular non-executive director, then in that case, at least one half of the board director shall comprise of independent directors. So the further regulation state the composition of committees. So the audit committee shall have at least 3 members, out of which at least 2/3 of members shall be independent director, and the chairperson of this committee shall also be an independent director. The audit committee part and the recent amendment of related party transaction and what should be the role of independent director in that committee is defined in further slides. Then a nomination remuneration committee. NRC shall have at least 3 directors. Only non-executive director can become member of NRC. At least 2/3 of NRC shall be independent director, and of course the chairperson of NRC shall be independent director. The chairperson, whether the chairperson of the company, whether executive director or non-executive director, may become member of NRC but shall not chair the committee. Then the stakeholder relationship committee. This committee shall constitute at least 3 directors, which at least one being independent director. The chairperson of SRC shall be the non-executive director. Then a risk management committee. The majority of members of risk management committee shall consist of members of the board of directors, and in case of listed entity having outstanding SR equities, equity shares, at least 2/3 of the risk management committee shall comprise of independent directors. So this is the composition as per LODR, and in case of Companies Act, the audit committee, NRC, there should be the majority of independent directors shall comprise the board of directors. And stakeholder relationship committee is applicable for companies having 1,000 shareholders.
One point to be noted that panel, if you observe that everywhere they are now insisting chairperson. So earlier we know that chairperson is for meeting as an administrative position. Yes, one specific as regards casting vote and all that is fine, but majority role is there. But this amendments and this composition has given a very specific position to chairperson and occupation of it by independent director. Your view on the same, why insisted that way?
And I think this is a very valid point because typically if you see what is the role of the person chairing the meeting is to ensure proper conduct of the meeting. But now with these committees coming into position where the independent director is ensured to be holding the position of chairperson, which is as against the word chairman now used, it is not just holding the meeting, but it is also to ensure that the role and responsibility of the committee is complied not just as per law, but in spirit. So when especially for listed companies, when we see there is a scope which is defined in the schedule 2 for each of the committees, audit committee, nomination and remuneration committee, stakeholders relationship committee. Now recently for risk management committee, it has been added. So that scope is a broader guideline for the committee to perform its activities, but essentially the committee is expected to stick to its core purpose of ensuring the purpose for which it is formed, and that's the role of the chairperson. What is also practically expected and what we have observed is the chairpersons of these committees are in touch with company secretaries ahead of the board meetings to understand what are the agenda being discussed at the meeting, what are the crucial points that need their attention. If there are any specific questions that they have, they need any more information from the management. And after the committee meetings, they also apprise the board of what has been discussed at the meeting. So beyond the minutes which have been circulated to the board, so that's a statutory process. Any committee meeting that has been held, the minutes are circulated to the board. But beyond that, the chairpersons specifically discuss those key aspects at the board of the key aspects of the discussion or any decisions which have been taken by the committee. So I think that's a role of connect between the board and the committee, which is now ensured by the chairperson, and that's the role I think we should look at.
And I think the main thing is that the role of chairperson is to promote a healthy discussion, ensure that each one has right to express the view, and there is a discussion, and if there is even the negative view also, allow it to be discussed and expressed. And the last but not least, the minute, how it is worded and finalized and put it before. I think this all is required to be independently done, so it convey the meaningful meaning of the discussion.
Absolutely, absolutely.
That means more and more responsibility has been thrown upon the independent director. That is one.
Yeah.
And the second thing is that they want not only the board, but the entire committee should function independently in its own and appreciate. That is the second thing. Third thing is, as we are all aware, the chairperson will always have one of the casting vote. So in which case, what happens is if anything goes, etc., he gets the discretion in leading a better decision-making process in the larger interest of the stakeholders. That is what I will pursue.
Right. Okay. Thanks. Go ahead, Nikhil.
Yes. Uh, the next slide is about the resignation of independent director, about all processes, then the effective date of resignation, what is his liability after resignation, and the disclosure to be submitted. So the process is independent director give notice of resignation to company firstly. Uh, then the company shall file DR12 within 30 days of receipt of notice to ROC. Then company needs to mention this the same in the director's report as well as on the website of the company. Then in case the company is listed, it should be intimated to the stock exchanges. Then the DR11 requirement is not mandatory nowadays, but still the certain companies follow the practice of DR11. Then in that case, it should be intimated to ROC, inform DR12 within 30 days. Then what should be the effective date of resignation? Uh, the notice received by the company or the date specified in the resignation letter, whichever is later, shall be the effective date of resignation. The liability after resignation, the independent director shall liable even after his resignation for the offenses occurred during his tenure with his knowledge. Then the disclosure, the listed company needs to make a disclosure to the stock exchange within 7 days of resignation, along with the resignation letter mentioning detailed reason, name of other listed entity in which the said director is also director, disclosure in corporate governance, then the disclosure in corporate governance report, along with the detailed reason of resignation if such director resigned before the completion of his tenure. Then as per a recent amendment, independent director who resign from a listed entity shall not be appointed as an executive or a full-time director on board of director of listed entity, its holding subsidiary associate company, or on the board of the company belonging to its promoter group, unless a cooling off period of 1 year has elapsed from the date of resignation as an independent director. Shall I move ahead?
Well, one question has actually come.
I think that as regards two chat question, I think both are at present not that. Maybe we can take last one.
Okay.
As regards that independent director meeting, let it come on the slide. So I have not taken. And as regards question last, which is just referring to the requirement of regulation 17, where it refers to the board composition to have minimum number of independent director based on category of chairman. What happens if just referring to the requirement of regulatory 17, where it refers board composition? What happens if a board does not have regular chairman?
Then it is 50%.
Okay, thank you. Yeah, go ahead, Nikhil.
Yeah. So removal of independent director. Company may remove director not, of course, appointed by tribunal before expiry of his term by giving him a reasonable opportunity of being heard and passing an ordinary resolution as per Companies Act. An independent director reappointed for second term, and in that case he is getting removed, then in that case the special resolution is required to be passed. The process where a special notice received by company from shareholders holding 1% of voting power, then the company shall send copy to the director concerned, who shall be entitled to be heard on the resolution at the meeting. Director may make a representation in writing to the company and request its notification to all the members of the company. if due to insufficient time or for the company's default, the director may be heard at the meeting of members. If any defamatory issue created by the director, the reimbursement of the expenses made by the company would be recovered from such director.
Vallari, I got one doubt here. If I understand correctly, the removal of the director procedure is one and the same for all the directors. Whether it is a other director or independent director, whatever it is, there is no special procedure as such designed separately for the independent director.
That is right, sir. The process is same.
Yeah.
As regards Companies Act, I think it provides for an ordinary resolution, or it is also a special resolution.
No, that is right. But what I am saying is, when you are talking about so much thing on the independent director, when it comes to the removal of the independent director, don't you think the regulator should actually have certain more checks and balances, analyzing the reason, finding out whether it is there or other than the director, because it is one and the same for all the directors, including the independent director. Okay, everywhere we are given the importance to the independent director, talking about the role responsibility, higher responsibility, etc. But when it's come to the removal, they are also treated like any other director only. There is no, specific things happening. Don't you think so?
See, sir, I think as a director, if they are being removed and if there is a reason and they are being given a chance to represent, at least I cannot think of something more that they should do for a fact being removed. Resignation, obviously, they need to make more disclosures to protect themselves from because of the reason for which they have been resigning. But as regards removal, I think if they've been given enough opportunity to represent themselves, maybe that should suffice. But if there is something that SEBI can consider for a time period which they should be given before they are removed to ensure that maybe all their responsibilities, or if they have any specific comment to be put up in the public domain for a particular period, so that at least they are making their facts clear or their position clear, I think that could be considered by SEBI.
The promoter
that can be ensured through the reply that he can give, process point number 2 of process.
Right. No, I'm just saying that in case if it is even before it is taken to the shareholders, if that kind of time be given to him to explain his facts and the case, that could be thought about. But I don't know. I think for every director, that removal is a process when it is the extreme step taken by the company for a certain reason, and they have been given opportunity to express themselves. What else can be expected? I don't know. Maybe you can explain with your experience if any such situation has happened in the past.
No, with me also removal has not happened, but the otherwise also independent director removal, and the comment is also in the chat box that independent directors so removed have liberty to speak. So if they consider themselves as being removed for any reason, they feel they should shout out. So I think the opportunity of being heard is given is itself, they have to speak and say is that.
Correct.
Mr. Ramana has raised the hand. You want to speak, then you can unmute and please speak.
So his rising hand is there right from the beginning. He has not lowered the hand
Okay,
from the last question.
Okay. Okay, then please go ahead.
So the vacancy of independent director, if any independent director resign or is removed from the board of directors of listed entity, then the new independent director to be appointed at the later of the following. First is 3 months from the date of vacancy or immediate next board meeting. If the board is fulfilling the requirement of appointing minimum number of independent director and the board composition is placed as per the regulation, there is no requirement of appointing a director in place of vacancy.
Nikhil, just to add, I think earlier this was the provision that within 3 months from the date of vacancy or the next board meeting, whichever is later. Now I think that has been removed and it is strictly within 3 months period. So practically, if you see, the board meeting would be held within a period of 120 days. But if that vacancy is caused on a particular date, your 3 months time starts ticking from there.
You are right, it is rightly pointed out, it's 3 months only now.
Yeah. I'll be explaining the role and functions of independent directors now onwards, which is as per Schedule 4 of Companies Act 2013. The independent director shall help in bringing an independent judgment to bear on the board's deliberation, especially on issues of strategy, performance, risk management, resources, key appointments, and the standards of conduct. Then the second role as per Schedule 4 is bring an objective view in the evaluation of performance of the board and management, that scrutinize the performance of management in meeting agreed goals, objectives, and monitor the reporting of performance. Then the independent director shall safeguard the interests of the stakeholders, particularly the minority shareholders. Then they shall satisfy themselves on integrity of financial information and the financial controls and the systems of risk management are robust and defensible. Then independent director shall balance the conflicting the interest of the stakeholders. Further, the independent director shall determine appropriate levels of remuneration of executive director, as they hold a major role in nomination remuneration committee. Key manager, then the remuneration of executive directors, key manager person, and senior management, and they should have a prime role in appointing, and whereby it is necessary recommend removal of executive director, key manager person, and senior management. And they shall moderate and attribute in interest of the company as a whole in situation of conflict between management and shareholders interests. These are roles and functions as per Schedule 4 of Companies Act of Independent Director.
Dipti, you have often been saying that I am very much interested in language flow, etc. See, in this whole thing, there is not a single repetition of the verb. Help, bring, scrutinize, satisfy, safeguard, balance, determine, moderate. Across Schedule 4, they have used so many verbs very nicely. Very nicely they've used them. But there is very little repetition of the verbs across Schedule 4. Paras 1, 2, and 3. If you are interested, Vallari, you can just look at it afterwards. Very nicely written, with no repetition of verbs. Anyway, since you always talk about this, I said I'll mention this here. Okay, Nikhil, please go ahead.
Yeah. I'll be explaining the role of independent directors in various committees and board meeting. So first of all, the role of independent director in board meeting, he should give the independent judgment on any matter of the board. He should prevent the management from taking a decision that likely to affect the interest of shareholders, stakeholders, creditors at large. Should ensure that any unethical behavior, fraudulent practices are not adopted by the board. Then shall ensure there should not violation of companies' policies. So in these cases, all the minutes and all these things every time get shared to the independent directors. Then in that case, he shall ensure whatever documentation is available with him, shared with him, he shall ensure the compliance at large. Then the role of independent director in audit committee. He shall have following rules to to recommend for appointment, remuneration, and term of appointment of auditors of the company. He shall review, monitor auditors' independence and performance and effectiveness of audit processes. He shall examine the material financial statements and the auditor's report. He shall review annual financial statements with reference of accounting policies, standards, and practices. As per recent amendments under LODR, all related party transactions shall require prior approval of audit committee, provided that only those members of audit committee who are independent directors shall approve the related party transaction. So that was a major amendment under LODR in the recent past. Then
I think, Nikhil, we are at 1 o'clock and we have to discuss decided case also.
yeah,
I'll request panel, I think role and all that, which is 1, 2, 3, 4. Can we skip and straight go to the case law or? Yeah. Yeah.
Maybe I think just on the previous slide, there was a question on that meeting of independent directors. If you want to
Independent director meeting.
yeah.
Yeah.
So
Yeah, please.
So there should be a separate meeting of independent directors of the company, and they shall hold such meeting at least one meeting in a year without attendance of non-independent directors and the members of management. So what their exact role in that meeting? They shall review the performance of non-independent director and the board as a whole. They shall review the performance of chairperson of the company, taking into account of views of executive directors and non-executive directors, and they shall assess the quality, quantity, and the timelines of flow of information between the company, management, and the board that is necessary for the board to effectively and reasonably perform their duties.
Yeah, now we can take a question. A question for panel. The minimum one meeting in a financial year for independent directors meeting is the responsibility of independent directors. The CS has limited role in this. In my practical experience in various listed entities, this is taken on record by the CS and reported in the director's report by the CS. How and what extent the CS should get itself secured from this compliance? Over to panel.
Dipti, as a company secretary, my job is to ensure that they are provided all the necessary things to conduct the meeting, because I am no party to the meeting, because it is their meeting. What they discuss, it is between themselves, I am not aware of it. But the only thing is, just meeting is held, for which I facilitated. After the meeting is over, I get the report from them. They held the independent directors meetings. The moment I get that declaration from them, I put it in my file. I have done my compliance. That is what, based on that, I am reporting on the director's report.
Okay, Vallari, your views?
Yes, so I'll share both the situations which I have personally experienced. A meeting of independent directors where the company secretary is not present, or it is only facilitated by the company secretary and completely attended by independent directors. So where, as Bala sir said, the independent directors discuss, they prepare a report, or they prepare the discussion points which should be minuted or which should be recorded as their discussion conducted. As a governance practice also, these points are then shared with the chairperson of the board so that they are aware of remarks by independent directors, and those are collective remarks. So there is nothing which is coming out independently by each person, but this is a collective view of independent directors for the betterment of the board and the management, which is then conveyed to the chairperson. That's how it is taken on record. The second scenario, where company secretary facilitates the meeting and also attends the meeting to prepare the minutes of that particular meeting, which in trust the independent directors allow the company secretary to prepare, and that's also permitted. They can ask the company secretary or any experts to join the meeting if they need any assistance or if they need any kind of guidance. And those minutes prepared are then shared with the chairperson of that independent directors meeting, who confirms the discussions, decisions being taken at that meeting, and the same again is conveyed to the chairperson of the board. So that's how practically you can ensure that you are compliant with the requirement. It is important that you at least set up the meeting and facilitate. You can coordinate with all the independent directors, get that time suitably, and arrange for a meeting. And then one of them who's then appointed as the chairperson for that meeting can give you the details if you are not personally present in that meeting. So I think I've shared both the scenarios where you are present or you are not present.
I have not come across in my personal life the second scenario what you have said actually, because I have been working with one of the Vodafone group companies where they had about 5 of the unlisted public companies where independent directors were there. But I have only coordinated with them, organized a meeting, etc. Another thing and all. They've been given all the facilities, and even I posted the technical person to ensure, okay, to conduct everything goes well, etc. And all this, because they are not very familiar with the presentation, etc. And other things and all. That is all. After that, they give me a declaration. Yes, they have conducted things and other thing and all. They will communicate to the chairman whatever the points, etc. in the discussion. I taken it and put it on the record. Based on that, I have given the thing. The second situation, the party to the meeting as a company secretary, in my practical experience, I am not. Yeah.
But as I said, sir, the very essence of a company secretary is to keep secrets. Correct. I think the independent directors trust that person to carry out the minuting part, and this is to assist the independent directors. The company secretary is not participating in the discussions. It's obviously the independent directors who discuss, but it is only to facilitate or conduct the meeting. The company secretary could be present, and that's with the permission of the independent directors. So I think that's possible.
Okay, thanks, panel. Nikhil, and just we can go fast on the slides now, which is the slides.
Yeah.
We should finish in another 20 minutes.
So I'll go to the next important slide.
Familiarization,
Familiarization
I would
program.
rather say that panel is, your views, because slide is there.
Yeah.
Your view on this familiarization program, its effect, and what is the view on your experience?
Yes, so I would look at familiarization program in 2 stages. One, before a person is inducted as independent director. So for him to understand about the company, about the industry, and about all the aspects that while being a director, the person should know. So here also we have prepared a standard deck of information that carries the annual reports for previous 3 years, the company performance presentations. Also, we have a list of people who should be interacting with the new director once the person is to be onboarded as an independent director. So there is a standard process or a set documentation which has been prepared that helps a new person to understand about the company and the business. Second is an ongoing process of familiarization, which we do through various programs or presentations made by different functions, which highlights about the various aspects being taken up in the company, the different projects, different processes, and also we have a quarterly update to the board on the regulatory and statutory updates or the amendments that are happening around. Apart from that, all the independent directors are free to speak to the company secretary or whoever concerned within the organization if they need any further information. So that's how I think they can be informed about the updates or anything with regard to the company, industry, or the statutory matters.
And also the updates on various laws and all that the board.
Correct. That's what I said. On quarterly basis, we present it to the entire board, the statutory updates and all the regulatory updates that have gone through in the last couple of months.
Dipti, my practical experience is also more or less the same, because whenever the director is inducted, what we do is we are actually prepared, sort of a material for the last 5 years, the company history, etc. and other thing and all, what are the rules applicable, what are the people who are in charge, whatever it is, and all this, they go through it. And we also ensure that we meet the senior people of the persons in the company, like, the marketing head or CFO of the company and the production head, etc. and other thing, and all, spend the time and understand the thing. We also take them to, I was working in a manufacturing organization, about 5 manufacturing units. So I used to take them to one of the manufacturing units and show whatever the processes, etc. with the concerned people, etc. and other thing and all. And as Vallari puts it, every board meeting, whenever they come the quarterly board meeting, even the other board meeting, we used to give the regulatory update from what has happened from the last board meeting till the board meeting, what are the things, various laws which has undergone update, where the company is actually standing. Are we prepared to gear up? Are we not prepared to gear up? Are we required any help, any sanction, anything from the board? What is the board rules, etc.? That we used to put. That is the ongoing way which we have been actually doing it. In addition to that, our chairman also used to suggest various programs, sort of the training program, etc., organized by the different organizations for the people concerned. I think you must attend, you should do this, etc. We used to dominate. People do attend for the training program, etc. They share their thoughts when they come back. That we were doing it.
One more just point I can add is, while the independent directors we discussed earlier have a greater role to play in the respective committees, what we also do is at the end of the year, the committee meetings which are held, we kind of present to them the compliance with respect to the terms of reference. So what is expected to be done by the committee, and during the year, what all actions which have been taken, if there is something that the committee needs to be highlighted.
Okay, thanks. Nikhil, go ahead.
Yeah.
Yeah. Case law.
So now onwards, I'll be discussing the case laws. So I have taken two case laws. One is with respect to a dividend, and the second one is insider trading code. And there are two another cases of one is NSE and the second is Satyam scam.
Nikhil, be brief on each case with small facts and straight conclusion.
Yeah.
And I request panel is as and when they want the comment, they can, so that we can finish early. People will be hungry now.
Yeah. So this case is with regards to transferring the dividend amount in the bank account of the company. So Dialog Systems Limited declared dividend, and they were not. They failed to transfer the amount in the bank account within 5 days of declaring the dividend. Then there is a provision that you should transfer the amount within 5 days of declaration of dividend. Then SEBI in their judgment, before SEBI anything stated, the independent director stated that they have no role in day-to-day activities, and they were not aware of these facts. So in the judgment, SEBI stated that the independent directors will also have to ensure the functioning of the company is in full compliance with the applicable law. And the further SEBI stated there is a violation of non-payment of dividend, stated that the company's board shall understand the necessity of ensuring statutory dues and dividends are paid without any delay. So the independent director cannot say that we have no role in day-to-day activities. So that is with respect to dividend case.
That means here again, the entire board process is actually followed. It is a compliance issue which is actually coming. The entire board is responsible for the compliance issue, irrespective of whether the executive director, non-executive director, the independent director. It is a collective responsibility to the board. He cannot escape the collective responsibility. That is what it comes out here.
But Bala, would an independent director be aware, into inverted commas, through board process? Through board process, that dividend has not been paid on time?
No, he will not come to know unless it is reported. But while recording, we normally write, because Vallari also will be knowing it, that when the dividend is actually declared, yes, we take a resolution, dividend declaration, opening a bank account, transferring the money within this.
We do all that,
all
but
the things
dividend is
there.
not paid. But dividend is not paid, and that is not recorded. So where is through board process?
No, that is not the board process, but he has to actually find out whether we have done the action.
No. Now the responsibilities which are spelled out in that schedule says he is responsible for matters which come to his knowledge through board process.
Correct.
Through board process, it has not come to his knowledge.
But it will come in the next board meeting. No,
next board meeting is after default has happened.
So he has to take a precaution. He has to ensure.
If at all it comes into the board, these matters will not come to the board. That we have not paid. Yes, Vallari.
No, it has to come because there is a statutory compliance certificate is to be placed in the board.
Statutory compliance certificate.
Yeah,
Okay.
because there is a non-compliance has got to be reported. That's a
Statutory-
discussion.
So there are, right, sir, there are two things. One, of course, Bala sir said there is a statutory compliance certificate.
Collective responsibility.
Second is the audit committee also in its terms has a responsibility to ensure if there has been any unpaid dividend. So it is again audit committee's role and responsibility to check that the dividend is timely paid to all the shareholders. If not so, then the audit committee has to inform the board, and audit committee has independent directors. So it's that committee's responsibility to apprise the board if there has been any non-compliance with respect to payment of dividend.
But all this will come to the board or come to the knowledge of the independent directors post facto.
It can be, yes, it can be post facto, but as soon as it is identified, there will be a corrective action.
Then he should start
Yes,
shouting.
yes.
Yes. For
So-
example, I was in a company, on the board of a company where they were not depositing TDS. They were paying salaries, not depositing TDS. I told them once. Second time when they did that, I resigned from that. So I'm guilty for the first part. Yes, collective responsibility. But at least I took action and resigned from that company.
So that will highlight why you are expected after the board meeting is over on the third day, you have to ring up. Oh, have you transferred the dividend? Another 2 days are left. Please ensure this. Otherwise, we'll be in the non-compliance.
Yeah.
So you are expected to
Your
go
action.
beyond the regulations.
Your action, when you
Yeah.
come to know.
That is what is required.
You have to inform the board, tell the compliance officer, and if that is not done, you have to put the foot down and say that we are objecting, and if you are not informing, then there will be non-compliance, same is not acceptable by independent, that kind of action.
Just a
You
minute.
can't say that I am not knowing the things.
Correct.
Yeah, Nikhil, next.
So the next case is with respect to insider trading code. So the board of directors of Ramswarup Industries Limited, that is RIL, had failed to adopt the model code of conduct as per CBPIT regulations, and the further CB issued the notice that the PIT insider trading code has not adopted by the company, and the responsibility as per PIT regulation lies on all the board of directors. The independent director stated, apart from the compliance officer, if any deficiencies, code cannot be saddled to other directors. So they were formally saying that independent directors cannot be held responsible for certain clauses being allegedly not there in model code of conduct adopted by RIL. So in the judgment, the adjudication order in matter of this company, directors, all directors were held liable for any act, omission, and commission by the company. So CB was at the view that it was duty of all the directors, including independent directors, exercise due care, skill, and diligence. So at the end of this judgment, the directors, including independent directors, shall ensure there is a proper code of conduct under insider trading code or any other regulation. So they shall ensure these things.
Yeah, I think it is quite clear. Next.
Yeah. So there is one popular case.
I think we can skip Satyam. Satyam is discussed enough.
Yeah.
In the paucity of time. Panel?
Yeah.
Yes,
I think, we are very well aware about Satyam.
Yeah, and NSC, Satyam and NSC. And what else?
There is end of slides.
I think Satyam and NSC is too much told. Sorry, Nikhil, you have worked hard.
Yeah.
But the thing that if we keep on negotiating, discussing this, it will be long. And we, as a practice, we generally finish maximum by 1:30, not beyond that.
Dipti, only one thing is there, you might have also noticed, even I was discussing with Vallari yesterday when we were talking. Very recently, I think about 3-4 days back, there was a news item which was appearing on the news.
1 minute, Bala.
Yeah.
Nikhil, you can close this thing. And thanks for the good presentation. Yeah.
2-3 days back, there was a news item which actually appeared. The independent director can actually aid for the startup companies and help them to grow. That is the news which has actually came about 2-3 days back. I think that seems to be the move now, how independent director can actually bring about the change for the startup companies in India and contribute in growing them, etc. That was the latest news which actually came about 2-3 days. That speaks about volume of the independent director and the independent director contribution which the regulator wanted to recognize. I just wanted to bring to your notice.
Yeah, very interesting, because independent director comes from various fields, and that will help them to, we can say mentor the startups in their own venture. It's very interesting, and I
And
don't.
I think,
Yeah, please, Pallavi.
yeah, I think this is quite right move, because the startups essentially have an accelerated growth plan. So while they want to grow faster and grow larger, it should not hamper the investors' interest or the country's interest as well in
Right.
terms of the overall governance, because they should not be cutting corners while getting ahead on their business plans, and ensure that all the other aspects are also taken care. So when we look at the role of independent directors, or for that matter, the corporate governance itself, the statutory provisions are only to help them assess or understand that how they can exercise care and caution. But in every respect, every decision, the way they can contribute in understanding the business, of being aware of the risks, aware of the results, and then take a proper decision, is what the independent directors can add value to. I think that's where for startups it will be quite essential.
It is really welcome move. It will be. It will
And
help.
one more thing is there. Even if you appoint a voluntarily an independent director, then in which
Right.
case also all the statutory regulation requirement fulfillment, everything will actually apply. You cannot say mandatorily I am not required to appoint the independent director. Still, I appoint the independent director. I am not complying with that. That excuse cannot be there. So automatically, all the regulations, all the requirement, statutory compliances, everything will become automatically
Absolutely
applicable.
valid, sir. Absolutely valid. This has been spelled out in the Secretariat Standard 1, that
Yeah.
even if you appoint the independent directors voluntarily, you have to comply with all the applicable provisions. So this will be certainly a very good move to ensure that there are proper meetings held, there are proper records of the discussions being taken, and then which are taken to a logical and proper conclusion and effect.
Why I brought this to you is when I was working in the Vodafone group of companies, we had a private limited company. That is, Vodafone Services India Private Limited. They wanted to appoint the independent director. I told them there is no requirement for independent director. There is no requirement, but we still want to appoint an independent director. We have a very technically highly qualified person who can contribute to our business. Then I said very categorically, no problem. There is nothing how you can. But the only thing is, these are all the things which will become applicable. We have to ensure these applicabilities are not. They have accepted, they have gone ahead with that. That is why I thought
Very good. Very
Right,
good.
sir. And just to add to that, ma'am, this of course applies for the listed companies, but this has also been included that for even the unlisted material subsidiaries, the independent directors need to be appointed there. So that also ensures an additional level of corporate governance on those material subsidiaries, and which earlier it was only incorporated in India, which then modified, incorporated in India or overseas, which means wherever in the globe your material subsidiary is based at, the independent directors should be there to ensure that there is a proper governance.
And looking at that means entire governance, compliance, stress is more on independent director, and that's why that they should have more knowledge of their role, responsibility, and the powers and expectation, and that's why I think eligibility and the exams, that is necessary, because the companies as regards orientation program, this was expected, but the both party were not serious or many times not clear. I think that exam and that one has to be very clear and educated and aware that what is expected. Thanks a lot, Nikhil, for your good presentation. Thanks, Vallari, Mr. Bala, Sailesh Bhai. Thanks a lot for your contribution.
Thank you.
Before you close, I want to convey special thanks to Vallari. I think she has, up to all the panel members I've seen on our program, I think she has been really the best. She's
Wow.
very knowledgeable, very articulate, very accepting of suggestions made. And I think Dipti, you should involve her in more of our panel in our programs more often in future as a
Thank you,
panel
sir.
member.
Thank you so much.
Vallari, it's very good distinction you got, huh?
No.
Thank you very much. And we'll really be
Very
happy
good.
to be
Very good.
participating in more discussions. Thank you so much.
Thanks, Miss Minal has joined today. Minal, thanks for your participation, and I hope you will join again. And please give your feedback, all the participants. If you have any suggestion or how you like, it will help us. Thanks, everyone. Thanks. Have a nice weekend. Thank you.
Thank
Thanks
you.
a lot.
Thank you, everyone.
Have a
Thank you,
good day. Take
Yes.
care of you.